Hello everyone, and welcome to the first broadcast of a 5-part webinar series that is being put on by the ACS Chemistry and the Law Division. I'm Mike David, and I will be your host for today's broadcast, which is focusing on the nuts and bolts of obtaining a patent. We will be joined today by Maureen Queler and Krista Bianco from the firm Finnegan, Henderson, Farabow, Garrett, and Dunner, who will explain that obtaining a patent is an important collaborative process between inventors and their patent attorneys involving many strategic decisions. If you have any questions or comments, you can enter those using the questions panel. The slides for today's webinar can be downloaded from that same panel. The recording will be sent to you once it has been posted. And now, I'm pleased to turn the time over to Krista.
Thank you, Michael, and thank you everyone for joining us today. Maureen and I are both members of CHAL in addition to being patent attorneys with the law firm of Finnegan, Henderson, Farabow, Garrett, and Dunner in Washington, D.C. And just a quick plug about CHAL before we jump into today's topics. While this webinar series is focused on IP-related issues, CHAL's focus is much broader. And for example, at the upcoming San Francisco meeting, CHAL, we typically offer programming on forensics, use of scientific information, FDA, and environmental regulation. So we have a diverse membership as a division with attorneys, researchers, academics, and students, and we welcome anyone who isn't a member of CHAL but would like to join and to become involved. We're a division that really runs on our volunteers. And so if you're not a current member of CHAL but would like to receive our spring newsletter, which will describe more of our activities at the San Francisco meeting, please send me an email. My contact information will be at the end of the webinar. But now just to focus on what we're here to talk about today, what we hope you will learn from today's presentation is, first, what is a patent? What are the timing considerations for filing a patent application? What types of information should I include in my patent application? And finally, what will happen after I file a patent application in the United States Patent and Trademark Office? So just a quick poll question to kind of get a sense of who's joining us today. I'll turn it over to Michael for that.
All right, so we would like to know which of the following best describes you. And with this interactive poll, you can click directly on the screen. Are you a named inventor on a patent? Are you a little knowledgeable about patents but would like to know more? Are you a self-described patent expert, or are you a patent novice? And once again, you can click directly on the screen. And a reminder that we're looking forward to getting some questions from you. And the earlier you ask those questions, the more of a chance we'll have to get to them. And with that, I'm going to close this poll in 5, 4, 3, 2, 1. And it looks like kind of a mix. 40% are actually a named inventor on a patent. 33% are knowledgeable but would like to know a little bit more. 11 are patent experts, and 16 are self-described novices. So sounds like a pretty good mix.
Yes, and we hope to, well, we will generally talk about a lot of things. If you have a more detailed question for those that might be more of an expert, please feel free to type it in, and we might be able to answer more detailed questions at the end of the webinar. Next slide. So for those patent novices out there, what is a patent? On the screen you'll see this is the gold ribbon copy that the inventors of the patents hopefully have gotten from the patent office once they've gotten their patent. But a patent is a bundle of rights that is granted by a government for a limited period of time in a particular country. So each country around the world has its own patent office, and if an inventor wants to patent an invention worldwide, the inventor would need to apply for a patent in each country. And basically, why do countries grant patents? Basically, a patent is a quid pro quo that encourages inventors to publicly disclose their inventions so that others can learn and build upon the new discoveries. And in exchange for publicly disclosing the invention, a government grants that owner a limited duration monopoly. So what rights are in the patent bundle? A patent allows the owner to prevent others from making, using, selling, offering for sale, and importing whatever is patented. Note, however, that a patent does not give its owner or inventor the right for the owner or inventor itself to practice the invention. A patent only allows the owner to keep others from practicing the invention. And an example of that is, for example, you could have inventor A who discovers and patents compound A which is useful for treating lung cancer. And then you have inventor B, who discovers and patents the use of compound A for treating breast cancer. And by enforcing his patent, inventor A can block inventor B from ever making, using, or selling compound A, even for the use of breast cancer. But inventor B can block inventor A from using compound A for treating breast cancer. So that's just something important to keep in mind for what rights a patent actually gives you. What are the statutory requirements for a patent? These requirements are set forth by Congress as the requirements to get a patent. And so the first one is that your invention has to be directed to patent eligible subject matter. That's kind of that it's useful. There's 4 statutory categories for what is patent eligible subject matter. It's machines, compositions of matter, articles of manufacture, and processes. Within those broad categories, all those subject matters are patent eligible. What you can't patent, though, there's certain exceptions that you can't patent inventions that wholly embrace laws of nature, natural phenomenons, or abstract ideas or equations. It's possible that methods or products that employ abstract ideas, natural phenomena, and laws of nature may be patentable, but if your whole invention is that you've discovered a new scientific equation, that's not patent eligible subject matter. The other thing that you would have to show with your invention is that it has a specific, substantial, and credible utility. Broadly speaking, the threshold of utility is not high. An invention is useful if it is capable of providing some identifiable benefit. A classic example of an invention that was not found to be useful is a perpetual motion machine. So it's kind of those types of inventions that wouldn't have a recognized utility. The next requirement for getting a patent is that your invention has to be new over the prior art. So if there's a publication or another patent out there that describes every aspect of your claimed invention, then you would not be entitled to a patent because it's not new. The next requirement is that your patent can't be an obvious variation over the prior art. So if you, for example, if you submit a patent application for a chemical process using a particular solvent, and there are publications out there already known that describe the same process using a different solvent, the patent office may say that that invention was obvious based on the knowledge in the prior art that other solvents would work in that same reaction with the same predictable results. There's two other requirements for a patent, and that really has to do with how much detail you put into your patent application, and Maureen will be talking about these a little later in the webinar, but I just wanted to give you a brief overview. The next one is that in your patent application, the patent must describe what you think is your invention in a way that's understandable by others, and it actually shows that you actually invented what you said you invented. The last requirement is what's called enablement, and that is that the patent must describe the claimed invention in sufficient detail to enable another chemist to make and use the claimed invention without undue experimentation. So as an example, if you discover a new chemical compound, you would need to describe how to synthesize that compound in enough detail that another chemist could also make the compound. That's kind of part of the quid pro quo of getting a patent, that you've basically shared what you've discovered in enough detail with everyone else so that they can repeat your invention or build upon it. So next slide. Okay. So for those patent novices out there who maybe have never seen what a patent looks like, this is an example of a cover sheet from a patent. And this is for a sealed crustless sandwich. But what you can see is at the top, you tend to have the issue date of the patent. It lists the inventor's name, the title of the invention. It's given a serial number. That's the application number. That is when you file an application with the U.S. Patent and Trademark Office. Each application gets a number that's called the serial number. The filing date is the date that you file the application. And I think Maureen will touch upon this, but usually the filing date is the date that the Patent Office will use to evaluate if it was new and novel and non-obvious as of that date. So it'll look at all prior art prior to your filing date. And then if there's any drawings or schemes or pictures, those may be shown on the front page. And there's also typically an abstract, which is a one-paragraph summary of what basically the invention is. And then there'll be a description, so basically all the other pages between the cover sheet and the end, which is where you have the claims, will be the description of here's what I invented, here's how you make and use it, and Maureen will be touching upon that further. So next slide, okay. So basically the claims of the patent are the numbered paragraphs at the end of a patent. And as you hear more from Maureen, there's a back and forth with the United States Patent and Trademark Office, and that the claims of a patent typically change as that patent is examined. Usually in the initial application, the claims are quite broad, but an applicant may need to make amendments to make the claims clearer or to more narrow to avoid some prior art. But at the end of the day, the issued claims are the most important aspect of a patent. An owner can only exclude others from doing what is described in the claims. And so the claims are really the key. And in this regard, the claims are the fence that really let the public know where your property rights begin and end. And with that, I'm going to turn the rest of the presentation over to Maureen.
Thank you, Krista. So to start my section, I'm going to turn it to Mike for another poll question.
All right. So for our second question, how soon after your invention should you file a patent application? Is it once you've determined it has commercial viability? You should do it immediately, after you have demonstrated it, or never. And again, you can click directly on the screen to let us know what you think the correct answer is. And I will be closing this poll in 5, 4, 3, 2, 1. Well, the good news is no one said never. The majority at 47% said immediately. And after you demonstrate it, and once you have determined it has commercial viability, we're tied at about 25%.
Okay, thank you so much, Mike. So what's the real answer? Well, as with everything in the law, it really depends on the facts of the case. And in some instances, you're all right, other than the people that said never, which we would encourage everybody to file patent applications covering your inventions. But really, it can be a combination of all these answers. But in general, I would say that if you have a well-formed idea of what your invention is, then really the 47% of you that guessed immediately, you hit the nail on the head. So why immediately? Well, the U.S. is now in what's called a first-to-file system. So that means any new patent applications that are filed are examined now under this framework. Previously, the U.S. was a first-to-invent system. So while it is still important to file a patent application as soon as possible, and there were many benefits to doing so in the past, under the first-to-invent system, if you could prove you were the first to invent it, even though you filed later, you could still get your patent. Now, under this first-to-file framework, if you don't file your application first, someone could beat you to the PTO, and you no longer have that ability to say, I invented it first. So now, sooner is the better. U.S. first-to-file, run, as our little man is showing on the screen, run to the patent office. This means you often don't want to wait for a commercial embodiment. So what I mean by that is, say you invented a detergent with new and improved cleaning capabilities that use a new class of solvents. And you have 3 options in this solvent class, and they all clean super well, but they all smell completely different. So you want to do some marketing research, you want to do some testing to figure out which one you want to market, which will be your commercial embodiment. Which one smells the best? Well, as you're testing, if you don't file your patent application and you're waiting to get the results of that test, every day that you're testing the smell of those solvents, you're putting yourself at risk that someone else out there will come to the same determination that you did and file an application first, and you can completely miss out on obtaining a patent. So that's why you want to go ahead and file your patent application listing all of the solvents, even the ones that determine later don't smell that great, or you don't prefer the smell of them. If they all are encompassed by the idea of your invention, they all have this new and improved cleaning capabilities, you want to list them all, even if you're not eventually going to market that. As long as the one that you do market is in that list, your commercial product is protected. I know we had some questions I think I saw about, what data do we put in a patent application? And when I said earlier that it depends on, that it may not always be immediately, is because determining when to file an application is a balance between having enough support for your claims and to cover your ultimate commercial product, and waiting too long and risking someone else coming in while you're doing additional experiments. So really you have to ask yourself, and this is in consultation really with patent counsel, either a patent attorney or a patent agent, do I have examples? Do I have enough examples? Do I know how to synthesize this new compound? You know, do I have the compound, but as Krista said, we need to be able to put in the patent application how to make the compound. So do I know how to do that? Can I write that out? Do I know, is this just a research plan on what I intend to look into, or is this a completed invention? And this goes to the utility requirement that Krista discussed earlier. So an example that plays on this is that a lot of patent applications can disclose or discuss compounds that may be beneficial, for example, treating heart disease, but they don't contain any data or an example of showing the effectiveness of any particular compound or class of compounds. This could, and not in all cases, but this could run the risk of being identified as what we call a research plan rather than a complete and definite idea of an invention. So it could fail under that utility test. If you instead have a patent application that discloses that class of compounds for treating heart disease, and maybe you have some in vivo data or in vitro testing, some potency data, toxicity data, something that supports the usefulness and ties these compounds to treating heart disease, then you're in a better position to argue the utility of the invention. So really we emphasize the idea that you're going to talk to your counsel, you're going to talk to your patent attorney or agent, and you're to discuss whether or not your invention or your idea is ready to be put in application form. Really, if you take nothing more home with you today, though, it's important to remember that you should file a patent application before any public disclosure of your invention. That's a pretty good rule of thumb. There are some existing grace periods built into the law that will protect you if you do disclose or have some public disclosure before you file a patent application. For example, sometimes you can have a one-year grace period between your disclosure and your application, but really you're just complicating the issue, you're making things messy, you're raising yourself or putting yourself at risk for a challenge that you had some public disclosure before your application. So in our hypothetical about the dinner party, unless you want to have your guests sign non-disclosure or confidentiality agreements, which may not be the best from a hostess perspective, it may be best to leave your inventions out of the dinner party aspect. So let's turn to the next slide. Skipping ahead a bit, assuming you're ultimately successful and you get a patent on your invention, how long do these protections that Krista talked earlier about, you know, the fence that you have established, how long does that last? Well, for a patent, it's 20 years from the date of filing. There are some time adjustments if the patent office takes too long, but this 20-year rule is a general good rule of thumb calculation. We've listed some other time frames here for different types of IP rights out there just to give you some perspective. For example, a copyright is the life of the author plus 70 years. A trademark can be unlimited. But the limited protections afforded by the patent statute, that goes to the basic ideas behind why we have patents. And it's granting this limited monopoly, and the key word there is limited, in exchange for the disclosure of the invention. So you as the inventor tell the world about your invention, you get this limited monopoly, and making the monopoly limited allows others to innovate off your ideas later on. So it's in entirety, the idea is to spur innovation. So as I just alluded to, there's this idea called patent term adjustment. Many times you'll look to the face of the patent, and I know some of you, about 40% of you, are named inventors, so maybe your own patents have this on there. If you look at the face of the patent, you may see that it says under the filing date that the term has been adjusted by, you know, sometimes 1,480 days or something like that. What that means is that it may have taken an extra 1,480 days to go through the examination process at the patent office over what the PTO says is the normal timeline. So say an examiner takes, you know, 6 months to respond to you instead of the standard 4. You will start accruing what we call PTA, or patent term adjustment, for every day that's over that 4-month time period. So the time starts ticking. And the PTO does have metrics. They're trying to keep these numbers down. They're trying to have their examiners respond as soon as possible. But a lot of times, especially if you have an application that's pending at the patent office for a couple of years, you will accrue some of this PTA. One other note on the length of protection is that you're not done once you get your patent. You need to keep paying the PTO to maintain your patent and to prevent it from lapsing. So at 3.5 years, 7.5 years, and 11.5 years, fees are due that will allow your patent to stay in force. Okay, so now we go back to the beginning. You want to file an application. What do we include? So the basic parts of a patent application are the description of the invention. So what is the problem you solved? What was the solution? What was in the art before? You know, what's the background here? Tell me about heart disease and why you've been able to provide a compound that does not have adverse effects that, you know, the previous compounds have had. Also in the description of the invention, we'll talk about how you make any compounds that you're talking about to satisfy that enablement requirement that Krista talked about earlier. Putting in examples. Now, examples are not required, but as I mentioned earlier, they can be often useful in satisfying the fact that you have a utility for this invention and that you are showing people how to make and use it. You may identify different embodiments of the invention. For example, what solvents will work with the invention? So as I mentioned before, you may have 3, you may have 4 solvents. You may have a whole class of solvents that will work with your new detergent. You're going to want to list all of them in your invention just in case maybe down the line you really want to market, you know, compound B because it smells like raspberries, where originally you thought you wanted to market compound A because it smells like strawberries. If you put them all in your application, you know, you're ensuring that you'll have support for claiming all of those, depending on what you want to market later on. It's a good idea to also include drawings. If your particular application or particular type of application benefits from some visuals, so that maybe some graphs, some microscopy, especially in the material science field, any schematics, any results that you have that can be presented in a visual manner, we recommend including those as drawings. And then your claims, again, the most important part of the patent application, which I'll talk a little bit about in a couple of seconds. And then you're going to include an inventor oath and declaration. So for those of you that are inventors or already, you know that you have to sign an oath and declaration. Basically, about the validity of the application and what it contains. And so you will sign that, and that will be part of your patent application. Okay, so claims. The claims are what define the invention. They are a key and they're a required part of a patent application. They are what makes your patent application legally enforceable. So your description can talk about all different aspects of your invention, but if they are not included in your claims, they're not considered part of what you have the legal right to prevent others from practicing. So back to our detergent hypothetical. If you only list one of the 3 solvents in your claim, someone can come in and market a detergent with one of the other 2, even though it was in your specification. They can go ahead and market one of the other 2, and it is possible that you can't stop them. So even though the one that smells like strawberries is the one you wanted to market, you also want to include a claim to the other 2 that also clean just as well to prevent anybody else from coming to the market with that type of cleaning detergent. And here in this slide, our elephant is demonstrating the balancing act of including claims that have sufficient scope. So, you know, we want all those solvents that are good, but we also want it to be narrow enough to avoid what was already known in the art. So if you try to claim something that is already known in the art, you won't get a patent. So that would maybe be a balance between putting 3 solvents in there that are new, but not including a 4th solvent that is out there and already known. So you want to do this balancing act. So this next slide shows the different categories of claims, and many times it's important to realize that one discovery can lead to all different types of claims. So it's really important to discuss with your patent counsel all of the different ways to protect your invention. For example, a new drug, a new compound that's useful as a drug can be protected as the compound itself, maybe even the method of manufacturing that compound if it is new, and a method of treating a patient suffering from a certain disease like heart disease by administrating that drug. So it's really important to have a dialogue with your patent counsel to make sure that you file applications that will cover all of these different types of claims. Okay, so here we're at the PTO. The where you go to get your patent. What is the PTO, how it's organized, and how it's functioned. So the Patent Office is responsible for examining patent applications, granting patents. They do post-grant proceedings, which is something new within the AIA, which is the America Invents Act, that was in 2012, which started these new type of post-grant procedures where you can challenge the validity of a patent at the Patent Office itself. The PTO, as I mentioned, is also in charge of patent maintenance. And then, as they say in the title, United States Patent and Trademark Office, the Patent Office is also in charge of trademarks. So how is the Patent Office organized? It is a technology center, so it's broken up into different technology centers that then include multiple art units focused on particular areas of technology. So the technology centers are really your typical areas of technology: business methods, chemistry, mechanical, electrical, and then your group or your art unit will really dig down into particular subsets of technology. For example, and this is the Technology Center and the art unit that I worked at when I was a patent examiner. So Technology 1700 is chemical and materials engineering, and then I worked in 1780, which was specifically focused on food and miscellaneous articles that are associated with food, so packaging and apparatus for making food. And the art units are pretty well delineated so that you have an examiner that is generally familiar with the subject matter that your patent application is claiming. And when you have an invention, it goes from the inventor to the patent lawyer or agent that will draft the application to the PTO. And throughout this whole process, especially when it's at the Patent Office, the PTO, the lawyer, and the inventor will all communicate through the process of prosecuting the application. Through these next slides, I'll walk us through the process of obtaining a patent from the Patent Office in a pretty broad and general aspect. If anybody has any specific questions, please feel free to enter them in and we can just talk about them in a little bit. So first, it's important, as we've emphasized all along, to have this constant line of communication between your patent counsel and your inventor. The first step is reviewing your inventions, discussing the pros and cons of pursuing applications on different aspects. If you're a large company, what inventions meet your goals or standards or what you would like to market, and then you go ahead and you start drafting your patent application. The next, a patent attorney will typically file what we call priority applications. So these would be best described as placeholders. For example, in the U.S., companies will file provisional applications that hold their filing date, maybe while they do some additional testing to see if they want to pursue this area. The provisional application is confidential, it's not publicly available, it lasts for 1 year, and at that 1 year time you have to decide whether or not you want to file what we think of as a typical patent application, also called a non-provisional application. So after you file all of your necessary papers and your application is in good form, it goes to your examiner, and the examiner will look at your specification, they'll look at your claims, they'll do a search of the prior art to determine, prior to that filing date that Krista mentioned earlier, whether or not there's any prior art out there. So that's patents, printed publications, if anybody's talked about knowing about this particular technology or particular invention in the prior art, and the examiner will look at all that and they will draft what we call an office action. Now, many times, depending on the technology, it can take approximately 6 months up to a year to get an office action from the PTO. The PTO is constantly working to reduce this wait time, but sometimes it can be frustrating, especially when you've done such a race to the PTO to file your application and it seems like you're just waiting. There are different programs that the PTO is trying. One is called Fast Track, where you can pay a little money and put your application in a certain format, and the Patent Office says that they will get an answer back to you in office action, and the entire process will be much quicker. So the office action is the written communication from the examiner, basically with their analysis of the claims and your application. It will identify any problems that your claims have. For example, if you use terminology that isn't clear, the examiner didn't understand it, or for example, if you claim something that isn't supported by your description. If you start, in our detergent example, if you start talking about including an entirely different cleaning agent in your detergent and that is nowhere it's in your claims but is nowhere in your patent specification, then you may get dinged by an examiner for failing to have what Krista talked about, written description of your invention. They will also tell you any formatting problems your application has. A lot of times, if drawings are illegible, you'll get a notification about that. And then really the main part of your office action is a description of the prior art that the examiner is applying against your application. So this is, again, earlier patents or publications that the examiner believes discloses the same invention or a similar invention or makes your invention obvious. So the examiner says it would have been obvious from this piece of prior art to have used these solvents in detergent, for example. So after you receive your office action, the applicant can respond by arguing against the examiner's rejections, maybe explaining why the prior art does not cover your invention. You can also amend the claims. So say, for example, if we included the 4 solvents that we talked about and the examiner found one of them in the prior art, we could remove that solvent from our claims and send it back to the examiner and say, okay, we've removed the solvent that was in the prior art, here we're presenting just the 3 new ones, and see if the examiner can find any prior art against that. One option that applicants have, which can be very beneficial, is to conduct interviews with an examiner. So in an interview, an applicant or their counsel can explain the invention. If they think the examiner is confused or not understanding the point, they can discuss the prior art, what it does disclose, what it doesn't disclose. And really it's a chance to flesh out issues in person or over the phone without everything being in writing in an office action or in an office action response. So basically I have repeat here on the slide. This process, the office action response, interviews, that can be repeated over and over and over again with the scope of the claims being adjusted and the prior art changing until you get, hopefully, a notice of allowability. So that is the Patent Office telling you that we think your claims are in condition for allowance. Please pay us the issue fee. So you get your notice of allowability, you check to make sure that the reasons that the examiner said your claims are allowable, you check to make sure you agree with that, and then you can pay your issue fee and get your patent. One important thing to consider is, as I mentioned earlier, there's a lot of different types of claims that you can get from one invention. So say you have your invention and you got your compound claim. One discussion you should have with your patent counsel is, should you now file what's called a continuation or divisional application that's just following on to your original application, now claiming, say, the method of manufacturing that compound or the method of using that compound. So make sure that you don't lose the benefit of that early filing date, that rush that got you to the Patent Office. Make sure you file plenty of applications off of that to protect the entire scope of your invention. And here, our slide has some resources that we thought would be helpful for you. So we have our Finnegan website, which has a lot of good articles. Many go into a lot further depth and complexity than we talked about here in kind of our general overview. And a lot of good USPTO websites. The Patent Office has a lot of resources available for people that are just learning about patents, glossaries, frequently asked questions, and contacts in case you want to call and talk to the Patent Office about anything. They're actually relatively easy to get a hold of. So with that, I'm going to turn it back to Mike.
Thank you. The Chemistry and the Law Division focuses on educating others about the issues that arise at the intersection of chemistry and the law. They are organizing a number of IP-related symposia in San Francisco and invite you to attend, as well as join them for a drug and power lunch on Monday, April 3rd, and a networking reception later that evening. For more information on the benefits of CHAL and how to join, visit www.chemistryandthelaw.org or ask them at the reception in San Francisco. And now I think it's time to take our first question.
Yes, and we have a lot of great questions, so I'll try my best to get through as many as we can in the time we have left. Maureen, the first question is, you had a resource page, and there's been some questions about how much are certain PTO fees. Is that somewhere you can find on the resource page?
Yes, really either on the resource page, on the resource page I don't think I have a link to the fees, but if you go to the USPTO.gov website, you can type in fees and it will take you, there'll be a link to the most recent set of fees. Also, I typically just type that into Google, USPTO current fee schedule. It's called a fee schedule, and just make sure that it's the most current one because they do change, and they have actually just recently changed within, I'd say, the last year. And that'll give you a rundown of all the fees that you have to pay to the patent office. For example, you as the applicant need to respond to an office action within 3 months, but you can extend that time period for an additional 3 months for a total of 6 months in case you want to do some experiments, or you need some more time to evaluate the prior art. You would pay a fee for every additional month after 3 months that you would extend. So I think the current fee is about $130 or $140 to extend for the first month, and then it increases for the next 3 months.
You mentioned and discussed a little bit about the provisional date, a priority application, and Raj had a question. Is the filing date the provisional or the non-provisional date?
So the filing date that appears on the front of the patent will be the non-provisional date, but what you'll see, and I don't think we had it on the picture of the patent face or the patent cover that we showed on the slide earlier, but underneath on that face of the patent it will say this application is a continuation of either any previous applications that you filed, and it'll list their filing date, and then it also lists the dates of any provisional filing any provisional applications that were filed, and it will also list, I didn't touch on this, but there is the option to file applications in another country. For example, if you file in, say, Denmark, and then within a year you file in the US, it'll list those previous filing dates on the face of the patent as well.
So even though the filing date is the non-provisional date, what's the date of the art an examiner would apply then if you filed a provisional?
Certainly. So for a provisional, a U.S. provisional application, what we call the effective filing date is the date of the provisional, not the non-provisional. So the prior art would have to predate that provisional application. Now that's assuming that all of the information that's included in your claims is included in the subject matter of the provisional. So if you think of something to add to your claims after you file that provisional application, it's acceptable, but your effective filing date will be the filing date of your non-provisional because the subject matter isn't in your provisional. There's a different analysis for foreign priority, and so for that it's important to discuss the pros and cons of filing in the U.S. versus filing in a different country when you're pursuing a patent application.
A number of people have asked the questions a little bit about PCT or global patent application, and is more than one way to enter and file a U.S. patent application. Maybe you can speak generally as to what a PCT is and what its advantages might be.
Yes, definitely. So a PCT is called the Patent Cooperation Treaty, and so this is really a cost saver that allows an applicant to file one application at one time and then enter what we call the national stage in a number of different countries that are signatories to the Patent Cooperation Treaty. So it saves you time, it saves you money, it allows you to file the same application in a lot of different countries. So in my hypothetical, say you file your first application in Denmark. Within 1 year, you can then file a PCT application claiming priority to that Denmark application. And then during the time frame set forth by the PCT, you can enter the national stage, that's what it's called, and essentially patent applications will be filed in all of the different countries that you so choose. So there's a lot of different timing requirements for PCTs versus the standard U.S. practice, and so it's very important, I'd say, especially for PCT, to talk with your counsel and make sure that you understand the implications of all the different filing dates so that you don't miss anything and you don't miss a due date for filing or entering the national stage in any country.
And there was another question about how can researchers from foreign institutions apply for a U.S. patent? Are there any limitations? Or
No, so the U.S. patent system is open to all worldwide. So just because you're a researcher at a foreign institution does not mean you can't file for a U.S. protection or a U.S. patent. So just as someone in the U.S. or a country in the U.S. Can file for patent protection in, as I've mentioned, Denmark, someone from Denmark can also file a patent application and get protection for their invention in the U.S. So it's really a global patent system, and that's one of the reasons that the Patent Office, or the U.S. as a country, just switched from first to invent to first to file, because really that allows the U.S. to be consistent with the rest of the world. So previously the U.S. was really, I think, the only or one of the only countries that did a first to invent system. The rest of the world was a first to file system, and now with this change the U.S. is consistent with the rest of the world. So it really makes it a more globally accessible system.
there's also, and I think one of your slides touched upon this, that generally patent agents or patent attorneys can prosecute patents, and there was a question just asking, basically what are the opportunities for a patent agent, or what sort of job opportunities would they be able to do compared to a patent attorney in prosecuting a patent?
Well, I can't speak to current job openings for patent agents, but
the question wasn't yet.
But yes, so if you're a patent agent versus a patent attorney, first the difference between them is a patent agent is not a lawyer. So they haven't passed the bar, taken the bar, gone to law school, and so they are not a lawyer, but they have done what's called taking the patent bar. So that's different from your standard law bar, where you learn all about property and tax and different concepts like that. The patent bar is limited to just patent information, and so really any scientist can then become a patent agent if you study and take the patent bar and establish your proficiency in patent law. And then what that allows you to do is conduct business back and forth with the Patent Office. There are some limitations, both professionally and ethically, on the legal advice that you can give a client as just a patent agent. And so I'm not 100% up to date on really the differences between them, and usually patent agents work under the supervision of a patent attorney. But that being said, I think there are some patent agents that really conduct their own business and work on filing applications and corresponding with the Patent Office, because they have what's called a registration number. They've been barred by the Patent Office to conduct business. So I think there is, if you go on the Patent Office website, there is some frequently asked questions that touch on this topic. So I would encourage anybody interested in taking the patent bar to look into that, to determine really what the difference is between what a patent agent and what a patent lawyer can do. Yep, I think that's all I have to say.
One other question about a provisional application. Joe asks, if a provisional application is abandoned after 1 year by a company, does that application become public knowledge?
So that's a very good question, Joe. The content of the provisional application will not become public knowledge. So if you do not file a non-provisional application, the provisional will not become public knowledge. Only when you file a non-provisional claiming the priority to that provisional, and then that non-provisional becomes published, either because it's patented or patent applications get published typically about 18 months after their filing. On that publication date, then the existence and the contents of that provisional are considered to be public. But before that, if you never file a application claiming benefit to that provisional will never see the light of day.
There's been a number of questions about how much examples or how much detail you need to put in the patent. So do all of the examples need to be real compounds, or can you have some hypothetical examples? And then just generally, maybe you can talk a little bit more about, and I know it all depends, how many examples of real compounds you would need in a patent application, if there's some rules about it.
So there are no rules, and you actually don't even have to have examples. You actually don't even have to have ever actually done what you're claiming in the Patent Office. So it can be entirely prophetic. The the kicker or the key is that it actually, what you prophesize has to actually be true and has to actually work out. And if the patent office or say a later challenger can prove that it does not work, then your patent is not really worth anything. But it can be entirely prophetic. You can have entirely hypothetical examples, although I can see that being a little difficult to set forth. One thing that would be important is that if it is entirely hypothetical, it needs to be very clear that your example is hypothetical. You can't say that you have done this or indicate that it has been done. You have to be very clear that this is something that you think would occur, or if you did this, then you would expect this to happen. But there are no hard and fast rules on the number of examples or how many have to be real versus how many have to be hypothetical. Really, unfortunately, this is a very lawyerly answer, but it depends on your technology, how long this technology has been in the public. So are you talking about a variation on the compound that has been in the art for a very long time and it's pretty well described and everybody knows how to make it and what it does, and you're just developing a pretty unique and small part of it, and your invention is just kind of an expansion upon the already existing prior art, then I can see you getting away with not many examples because, basically the reader of the patent already knows pretty well what this compound is. But if you're working in a brand new field, brand new area of nanotechnology or something super exciting about that, and the rules governing it or the standards are just very undefined, then that would be a time where you would need more examples, because you're really going to need to show that you have possession of this invention. You knew what it was, you have a well-formed and concrete idea of what your invention is and the metes and bounds surrounding it. So that's kind of a general framework of how you can consider how many examples to have. Another, as I mentioned, another thing that can affect that is just your timing. Do you have time to do some additional examples? The more you have in there sometimes can help you because it allows you to support your written description. It may allow you to claim some additional things later on when you determine additional aspects are valuable to claiming for the product that you're looking at, but you don't want to take too long and have somebody else beat you to the patent office. So again, it's a balance, and that's why I encourage any inventor to have a constant dialogue with their patent counsel when they're looking at an invention that they think they want to patent to determine that timing.
And what about, or especially if you were wanting to file in multiple countries, is that something that might vary country by country as to what the requirements are in the country for how many examples and what type of examples?
Yes, that is definitely something where you would want to make sure you understand the requirements for different countries. For example, I think in Europe, and again, I'm not a European patent attorney, but I have worked with some, and Finnegan has an entire section that deals just with prosecuting patents in Europe. But there often are times where you can add examples to a patent specification after you have filed it in order to support what you're claiming. That is not the same in the U.S. So if you're working and you're a European inventor and you're used to being able to add things later, then it's very important to know that you can't do that in the U.S. Vice versa, that may be something that is a benefit to you from if you're a U.S. inventor or used to filing in the U.S., you get this nice knowledge that, oh, look, I can add some more later. So it varies greatly across the world about whether or not you can add examples later or what you can add and what you're stuck with once you file your application.
All right, let's see. There's an interesting question. I know you're not a representative of the Patent Office. Susan asks, is there an unwritten limit on the number of patents that can be granted each year? One examiner has apparently said that in an interview under stress.
That's interesting. Never I've heard before that there's a limit to the entire patent office's granting of patents. I know that there's a number of metrics that examiners get judged on. And so really how fast they allow patents, the number of what we call first action allowances. So that's a patent officer or patent examiner picks up your application, looks at it and says, you know what, this is 100% new, 100% not obvious, I don't need any more information, it's allowed. The patent office does not, internally, the patent office may be a little skeptical of an examiner that's doing that quite frequently because they don't think that that means they're giving them, giving that application a lot of consideration and prior art search if they're just giving first action allowances to everything that comes across their desk. So maybe that examiner was talking about some issues that him or her were having internally with some metrics that they're being judged against. There's also, I know they track the allowance rate of different examiners, and really the whole goal of the patent office is to allow patents. It's actually not to reject patents, it's to allow patents. And so the overarching goal of an examiner is to work with the applicant to try to determine and carve out really what this patentable subject matter is, and have your application proceed through prosecution in a timely manner and an expedited manner and get you that patent. They're shockingly not supposed to just prevent you from getting an application, although that's what it often seems like. So I think that examiner may have been, as you mentioned, under stress and maybe talking about their own particular metrics or the metrics of their art unit, or maybe heard their SPE, which is their supervising patent examiner, their boss essentially, maybe said something off the cuff that they maybe took to heart a little too strongly.
Generally, how long does it take to have a patent examined by the PTO?
So to begin examination, as I mentioned, it can sometimes take, 6 months to a year, depending on what technology you are. If you're in a technology that's being flooded with patent applications, I know for a while the software art unit at the patent office was very, very busy. They had a lot of applications come flooding in, and so the pendency to have an examiner pick up your application got quite long. But the patent office itself is really constantly working to decrease that pendency between the time that the application is filed and the application is picked up. It's also trying to decrease the pendency of the time that the application is in front of the examiner. So part of that is what I talked about, the patent term adjustment. So the patent office will give you days, extra days for the time over what they consider normal that your application spent, languishing before an examiner looked at it or before an examiner acted on a response that you filed. And you can take a look at what the Patent Office considers normal. If you, do a search of the USPTO.gov website for PTA or patent term adjustment, you can see kind of the standard time frames that they give. I know that if you have an application pending at the Patent Office over 3 years, that's one time point after which the Patent Office starts accruing PTA for your patent application that'll give you once your patent is granted. So unfortunately, the answer is not so clear. I can't give you an exact number, but it does depend on how busy the Patent Office is, how busy the particular examiner that's assigned your case is. One thing you can do, as I mentioned, is you can look to see what current programs the PTO is running. They've been trying a number of different ones in the past. I think the current one is the Fast Track program, where you have to have a certain limited number of claims, a certain limited number of what we call independent claims, which is your main claim, and then you have to pay a good amount of money, not too much, not prohibitive, but you have to pay more money than the typical application. And in return, the Patent Office says that they will expedite the prosecution of your application, and with the goal of obtaining a final resolution, whether that be abandonment by the applicant, whether that be allowance of this application within 1 year.
There's also a question about patent extension, that there is, a limited exception where a patent can extend beyond the 20 years of the original patent. If you could just speak very broadly about that.
Sure. So one way that it can extend beyond the 20 years is that patent term adjustment, but patent term extension is a different issue. One area that this comes up frequently is in the pharmaceutical area. So, and Krista, you may be able to talk a little bit more about this, but that is when if you have a patent application for a new drug that's pending long after it received approval, I believe you get some patent extension, but maybe you can talk a little more about that.
Yeah, there is another patent term extension for a product that is ultimately FDA approved, where you can get back some of the time that you were not able to market the drug because it was getting FDA approval. And so there's a whole bunch of requirements and regulations associated with that, but that's the other type of extension that allows you to go beyond the 20-year period. I think we're getting close to run out of time. I have, let's just do one other question. We have a question asked if it's advised. You've talked a lot about all these different types of claims that you could have to make sure you cover your product, method of making, usage, etc. Is it advised to have all types in one patent application, or is that sometimes more of a strategic decision as to how you present all of those claims?
So it's definitely a strategic decision, and it can go both ways. You can have all of your different types of claims in one patent application, especially, for example, if you have a product and then the method of using that product. Those are two ideas that kind of go together quite easily in one patent application. And what will happen is if you have claims to both of those, the examiner may choose to do what's called a restriction, and they will say you have more than one invention, more than one type of invention in claimed, and we're only going to examine one of those. And so you choose, you say, oh, I'd like you to examine the product claims. And then in discussions with your counsel, you can decide whether or not you're going to maybe hope the examiner will, at the end of the time, at the end of the examination, there's a procedure by which the examiner can rejoin the previously restricted out claims. So say they find that the product was new and non-obvious and they'd like to give you a patent on the product, they may rejoin the claims to using that product and allow them in one application. Otherwise, you can do what's called filing a divisional, where you file a follow-on application claiming the method of using the patent in a follow-on application, and you get the benefit of that early filing date when you had the combined application together. You also can file them all separately. You know, there's nothing to stop you from doing that, although a lot of times it can just get more difficult because you're developing a couple of different families of applications now to keep track of logistically. Also, if it's something that doesn't really fit in together, like sometimes the method of making a product is so wildly different of a discussion than the method of using it or the product itself, that may lend itself just from a writing perspective to better to be in a separate patent application.
And there'd also be a lot of costs if you have a lot of different applications.
So. Exactly. So it is a strategic decision. No one way is right for all applications. So it's just something that you need to consider with how many applications or how many different inventions you have, and what your cost and time frame is in prosecuting them.
And I noticed that we're out of time, so I apologize for not being able to get to all the rest of the questions, but we tried to pick a broad array of questions that covered a lot of what the attendees were thinking and asking us about, and I'll turn it back over to Michael.
All right, well, thank you all for joining us for the first broadcast of our series. Our next broadcast, Life Cycle Management and Research Opportunities for Patentable Inventions, will take place on March 14th and will feature Xavier Pillai from the law firm Leydig, Voigt & Mayer. There will be a short feedback survey that pops up as you exit this webinar, and we would appreciate it if you let us know what you thought of the broadcast. Also, remember that the recording will be sent to you when it has been posted. And that wraps us up. So thank you so much for joining us for this first broadcast, and we look forward to seeing you on March 14th.